Broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. It's 10 o'clock, so in the interest of time, we're going to get started. I want to welcome everyone here today. I am Eric Lufer, the president of the Citizens Research Council of Michigan. And it's my pleasure to welcome you to our webinar to review the three proposed constitutional amendments to deal with term limits, with voting rights, and with reproductive freedom. I should have done this. For those of you who don't know, the Citizens Research Council is a statewide nonpartisan public affairs research group. This is our 106th year of operation, a longevity we attribute to our promotion of sound public policy for state and local government through accurate, independent, and objective research. We are a private, not-for-profit organization, and we rely on charitable contributions of foundations, businesses, corporations, and individuals. If you get value out of our analyses of these ballot questions in this webinar, I encourage you to join our circle of supporters and help us to continue to provide high-quality, independent information on important policy topics such as these. Well, we're joined today by MERS, a daily news outlet that covers state government and politics in Lansing. John Rurink and Carl Mellon will join us later. They're with us now, you can see, but they'll join us later for the Q&A section. We've created a handout file with all the slides that are in the presentation if you want to have those for your own purpose, or pop over to our website to grab those to follow along. Please note that we are recording the webinar and we'll post it to our webpage where it will be available for future viewing. Also, we want to let you know that we have everyone but the presenters on mute, so we will not be able to hear you if you speak. We've received some questions as part of the registration process, and we'll try to respond to those. I think some of those are built into our presentation, but we'll try to get to others that aren't quite clear. If anything requires clarification, please use the questions or the chat function to let us know. If you have any technical problems, you can call our office at 734-542-8001. Let me know and we'll try to get that fixed immediately. You see here we have the links to the different ballot proposals if you haven't seen those already. And the Citizens Research Council has a email service. We send out bi-weekly emails to let you know what we've been up to with our reports and blogs and events coming up. And it's simple to join. Just text fax matter to 42828. Well, as I said, I'm Eric Lufer. I'm the president. I've been with the Citizens Research Council for 35 years, starting as a fellow, becoming a local government affairs researcher, research director, and eventually become the president. In that 35 years, I've dealt with most things dealing with state and local government, either with my own research or reviewing the research of others. So I'm going to talk about the term limits proposal. Craig Thiel's going to talk about Proposal 2. He has a long history with us as well. He was a fellow many years ago, went to work for the state, the Secretary of State, and then the House and Senate fiscal agencies, eventually came back to us and currently serves as our research director. Most of the time he's dealing with school finance, but as you can see, a lot of other topics with state and local government. And then Carly Abramson is going to deal with Proposal 3. She just joined our staff over the summer, coming to us from the Legislative Service Bureau. She has an academic background with a law degree, master's in public health, and a BA, all from the University of Michigan. Most of her work with the Research Council is going to be dealing with health policy. So I will let you know we're going to run through the three proposals. We have questions going to be posed to us from our friends from MERS. There is the opportunity to ask questions. If we have time to get to those, we will try to get to as many as we can. Otherwise, we'll follow up offline and try to get you the information. I already mentioned the webinar is being recorded and will be posted. And just a point of clarification, we're doing this not to advocate for a yes or no vote on any of these questions. We do not take positions on ballot issues or endorse candidates for office. We're doing this as a sort, we believe firmly that better information leads to better public policy. And in the case of this November ballot, you, the voters, are the policy makers. So we're trying to get you the information to make informed decisions. So let's get started. Started off, it was going to look like we were going to have a very long ballot dealing with ballot questions. At one point, we had 15 different proposals that were either in the works, out collecting petitions, being dealt with by the legislature. You can see with the number that were crossed out that many of those dropped off for one reason or another, and we're left with the 3 at the end dealing with the term limits, the promote the vote, and the reproductive freedom. So I'm going to talk to you about term limits. It deals with 2 things, the financial disclosure and a change in the way we affect term limits for our legislature. This is a language you'll see when you either get your absentee ballot or when you show up on November 8th. So what's it going to do? It's going to allow members of the legislature to serve a total of 12 years in the House, the Senate, or a combination of the 2. Currently, Michigan provides that a legislator may serve 3 terms in the House, 2 terms in the Senate, 6 years in the House or 8 in the Senate. So it's a forced change if you want to remain a legislator for as long as possible. This would change from terms to years in terms of the limit and change the total amount of time that a person could possibly be a legislator. How will that affect our legislature? Based on looking at California before us and thinking about some of the motives of the legislators that have, over the last 30 years, we think that it's going to allow legislators to go into the House, go into the Senate, and stay there for as long as the voters will have them, building tenure on a track to becoming committee chairs, whip, Senate Majority Leader, Speaker of the House, whatever, however high they can go in that leadership role. So one thing we did in our paper was to look backwards to say, is 14 years or 12 years, is that a increase in time? Is it a reduction in time? It's hard to know looking forward and how this change in going from terms to years will affect things, but we can learn from going backwards. What we found out was that over the 30 years that Michigan has had term limits, we've had 737 people serve in the legislature. 675 of people served as representatives, and most of the time they tried to maximize their time in the House. 60% of representatives served for the full 3 terms. Those who did not serve for the full 3 terms did so either because the people said, that's it, we're done with you, or they decided to run for the Senate and forgo one of their terms or 2 of their terms as a representative. In any case, some did go on to become senators. 160 people have served as senators in those 30 years. 2/3 of them have served for the full 2 terms. The other third only 1 term. So some of that is because we took a snapshot in time and there are current senators who are going to try to continue on, and others either decided they were done or the people decided for them that they were done. Of those 160 people who are senators, 98 of them, 61%, were representatives first. So we do see a very strong pattern of representatives moving to the Senate. That constitutes, so 61%. And of that group that where representatives became senators, 42 of them, or about 43% of the senators, served the maximum 3 terms in the House, 2 terms in the Senate. So what that tells us is 14 years going to 12, is that a extension, a reduction, is it neutral? 6% of people over the last 30 years have maxed out their time. Another 5% have served 12 years. So 11% in total would be affected by this 12-year limit as we look backwards. And it's important to note that those people, that 89% that did not serve the full term, would find eligibility. Of course, some of them had eligibility already and have not chosen to use it, but my takeaway from this is that a 12-year term will not affect many legislators going forward. There will, of course, be some who want to stay as long as the people have them, but not everyone. And so we'll see. It'll be a term limit for some people. We looked at how other states have implemented term limits, and you see Michigan here is in the 14-year group currently. You notice there's 2 other states that are sort of grayed out there. So in 1990, California implemented term limits. In 1992, Michigan and Arkansas did the same, and they all adopted basically the same pattern: 3 terms in the House, 2 terms in the Senate. So California in 2012 decided what we're going through. They just say this isn't working. There's issues with how people are being termed out and everything that we're dealing with. In 2012, they amended their constitution to go to 12 years total. In 2014, Arkansas made the same estimation, but they moved to 16 years total, allowing a legislator to choose how they want to use that time. And then it was a short 6 years later, Arkansas said, you know what, that's too long. It's not really term limits. It's not really affecting anyone. So they amended their constitution another time and moved it to 12 years total. So Michigan, with our chamber limits, 6 years in the House, 2 terms in the Senate, is as strict as any state. Nebraska is at 8 years total. They, of course, are a unicameral legislature, and so it doesn't matter what happens for the House or Senate. They only have 1 chamber, and that's 8 years. So Michigan ties with Nebraska having strict limits. Nobody has as strict of limits for a House as we do. So a change would put us in line with Arkansas and California, and Oklahoma's been in that group for some time. So as we think about this proposal, we're not asking to get rid of it, but at the same time, we had to ask, why do we have term limits, and have they accomplished what the proponents set out for them to do? One thing that was talked about 30 years ago was the idea of restoring accountability. The idea, Jeffersonian idea of a citizen legislature where people come and they serve some time and they go back, become citizens again, and live under the laws that were enacted during their time. So have we seen that? Yes, we've had artificial means of telling people you only get a limited amount of time and you'll have to rotate out. At the same time, for that full 30 years, we've had very strong gerrymandering in the state. Gerrymandering, the idea that the legislature creates districts and the party in charge can draw the districts to their benefit, create safe seats. So whether you're in a Republican district or a Senate district, many parts of the state have had this representatives from the same party for a long period of time. So while there has been a rotation of people, we haven't necessarily had a rotation of ideology or a rotation of fresh ideas coming in. Often it's been the party line for a lot of these issues. The proponents 30 years ago talked about restoring electoral competition. Of course, we're doing that. We're forcing legislative districts to become open districts and available for anyone to run. Again, the party leaders, you sort of see coming down the road that we're going to have an open seat. The parties have taken very active roles in recruiting chosen candidates. So yes, anybody can run. Yes, it's an open competition. We haven't necessarily seen this sort of competition that I think the proponents hoped for when this was created. They hoped it would reduce the special interest influence. Clearly, it's made the job of lobbyists harder, where they might be able to meet and educate legislators and tell them all about whatever their special interest is and why they should vote yes or no on certain bills. They still do that. It just, now you have to meet more people, do more educating, bring everyone up to speed. And we found that because of the turnover in the legislature, nobody's sticking around really for a long time to become policy experts in whatever committee they're assigned to or area that they work in. A lot of times the lobbyists have supplanted the district input that representatives would be getting, or supplanted the idea that you'll have a trusted legislator, somebody is that policy expert that you can go to. So it has made the lobbyist job harder, but we don't think it has lessened the influence of special interests. Finally, they talked about increasing diversity, trying to get more women and minorities into the legislature representing. We have seen more diversity. Clearly, you can go through and look at the makeup of the legislature over these 30 years and see that we have had more women, have had more minorities. It's not clear how much of that is related to term limits, however, because at the same time, we can look at other states, we can look at the federal government without term limits. We can see that there's more women, more diversity. We can look at business. We have a female head of General Motors and other major businesses. And we can look at civic organizations around us and see more women, more minorities engaged in different things. So yes, it's happened. How much of it is related to term limits is hard to say. So I just got done saying that they have accomplished what the proponents set out for. Why then are we thinking about amending them? Why did the proponents of Proposal 1 offer this amendment to change the nature and time of term limits? Well, they think that term limits have increased the amount of partisanship. It's already, of course, very strong nationwide, but they think if you can focus in on Michigan and other term limited states, that we are becoming even more partisan than other states. And they think that by doing so, that the legislators have shifted their focus away from the district, more interested in what the party is preaching than what their district constituents are telling them, have weakened the executive branch oversight executed by the legislative branch, and so on. So if we can, the idea is if we can allow them to spend more time in either chamber, they can worry more about issues and less about electioneering and focus more on some of these things that seem to have been forgone. The proponents of Proposal 1 allege that term limits have created an unwillingness to tackle difficult political issues. We've seen in the past policies be adopted where the implementation begins when that current class of legislators gets termed out. Leave it for the next group to worry about the backlash on some of the difficult decisions, and how much of that is pure politics, how much of it is trying to guess what the economy is doing, and how much is term limit is hard to say. Finally, the group alleges that term limits have weakened the chamber leadership because we have a Speaker of the House that is ascending to power after only 2 terms, only 4 years experience in the House of Representatives. The allegation is that that person really hasn't been around enough to know all the the tricks of the trade and really gained enough information and influence to be a strong party leader. The Senate Majority Leader becomes ascends to that office only after 1 term in the Senate. We, in our look backwards, we found that many of them were representatives first, so at least 4 years in the House before serving 4 years in the Senate. So 8 years as a legislator, but still not as long as past Senate Majority Leaders. And then because of the term limits, we see a lot of these chamber leaders have been really focused on fundraising for the rank and file, trying to keep the legislature in the hands of the Republican or win it back for the Democrats, rather than really getting into a lot of the issues. So again, trying to sway the focus away from electioneering, focus on the issues. Michigan challenged in so many different issues. So term limits is part of it. The other part of it is to mandate a law to deal with financial disclosure. This law, when enacted, would affect the governor, the lieutenant governor, secretary of state, attorney general, and members of the House and the Senate. It requires an enactment to reveal for each of these officials what their assets are, where their income comes from, not how much income, but what are the sources of income. To whom do they have liabilities? If they hold any positions in any committees, any nonprofit groups, anything like that, so we know what sort of influence they might have from outside the chamber. Do they have arrangements for future employment? We've seen the sort of the revolving door. You leave the chamber, and as the next group is sworn in, you move into an office across the street in Lansing and begin working for a lobbyist or some other group. Gifts received, whether that is small tokens that they get at conferences or major gifts, they would have to reveal that in some way. Payments made for travel. We've seen this a number of times. People go on these junkets and it's all paid for by someone. And finally, payments made in lieu of a charity, in lieu of honoraria. So the legislator doesn't necessarily benefit, but their favored charity does. So we, of course, have times to be cynical about different things our legislature does, and sometimes you can look at this amendment and think about, is this requirement for financial disclosure window dressing, or is it really substantive? It doesn't do anything but require that the legislature enact a law in the future. And what I would say with this proposal started off as a petition being drafted. So citizens were going to ask to put this question on the ballot. And as part of that, they had a two double barrel approach, term limits and financial disclosure. Term limits very popular, so could you win extra support with this financial disclosure? They convinced the legislature to put it on the ballot without having to collect all the petitions. And the legislature did so, but in doing so, because the legislature can enact this law anyways, they don't need a constitutional mandate to do so. In essence, what it boils down to is the legislature saying, we haven't done our job, and now we want you, the people, to adopt this constitutional amendment requiring us to do our job, and you should vote for this. So again, if there's ever a time to be cynical about something, this might fall into that group. So with that, I'm going to pass the baton here. I have to go here and make Craig our presenter.
All right, thank you, Eric. I now have the control of the CRC Mirrors ship, and I'm going to run through the Proposal 2 on the ballot in November, commonly referred to as Promote the Vote 2022. As Eric presented the ballot language for Proposal 1, here's the ballot language that voters will see at the voting booth, or if they're doing absentee mail-in voting, when they get those ballots in the mail. What I would note here, the language of the proposal deals with Article 2 of the Constitution, two sections, Section 4 and Section 7. Section 4 is the place, time, manner of elections. Section 7 has to do with canvassing boards. Just a little historical note here. Before the 2018 Promote the Vote proposal, Section 4 consisted of one section, and that was it. Following the adoption in 2018 of the Promote the Vote proposal, that grew to two sections with 6 separate subsections. If this current proposal is adopted, Section 4 will grow to 3 sections with 14 unique subsections. Similarly, we'll see a growth in Section 7 of Article 2 dealing with canvassing boards. Pre-2018, or really pre-Promote the Vote 2022, we had one section. Now we'll have one section with 7 subsections. So our Constitution is definitely growing with these voting right proposals that people are being asked to vote on. So a little bit about the motivations. There's kind of 2 tranches of groupings of motivations here. First, obviously, as I've alluded to, 2018 voters overwhelmingly adopted the voting rights proposals in the 2018 Promote the Vote. This had to do with no reason absentee, straight ticket party voting, or straight party ticket voting, automatic voter registration, requiring the Secretary of State to do audits of elections. The 2022 version can be seen as a follow-up on this earlier proposal, in that it's sketching out and broadening some of the rights having to do with the no reason absentee voting, including providing postage paid envelopes, which I'll get to, for applications, absentee vote ballot applications and voting. With respect to the audit provisions, it clarifies language dealing with the election audit provisions that were adopted in 2018. So that's one area of motivation. The second area has to do with our current political environment. The Promote the Vote 2022 proposal can be understood as a reaction to recent voting and election-related reforms proposed by the current Republican-led legislature. In the fall of 21, the Republican majorities in both chambers of the legislature passed several bills dealing with voting and election administration. The legislation included, among other things, provisions to tighten voter identification requirements, limit absentee ballot application mailings, and prohibit prohibit elections officials from accepting private funding for elections. Governor Whitmer, when presented with several of these bills, vetoed them, argued that the legislation would make voting more difficult, would disenfranchise voters, particularly voters in minority communities and senior citizens, and that the proposed reforms would not address claims of voter fraud that emanated from the 2020 presidential election in Michigan and across the country. Following the governor's veto of that legislation, proponents of the reforms set out to collect the required number of petition signatures for a wide-ranging statutory initiative. That proposed statutory initiative would amend the Michigan election law. It's referred to as Secure My Vote, and it encompasses many of the same reforms contained in the legislation vetoed by the governor in 2021. So the Secure Michigan Vote petitions are currently awaiting canvass by the State Board of Canvassers to determine whether or not there's a requisite number of qualified signatures. And if that certification's received under our Constitution, that proposal will first go to the legislature for consideration. They can adopt that in whole. If they don't, then it would go to the voters. So this political context is very important to understand as we look at what's in this proposal. Here we have I've identified the key provisions in the proposal. Additionally, I've noted where those provisions that would be new and those that currently exist within the election law or have been recognized by the Supreme Court. For example, the voter identification requirements included in Proposal 2 already exist under the election law, but the provisions related to early in-person voting would be brand new for Michigan. I want to note here that the voters face an all or nothing proposition with this constitutional amendment. A yes vote would enact all of these provisions. Also, it's worth noting that the proposed constitutional language represents a minimum or a floor, and nothing would prevent the legislature from expanding voters' rights beyond what is included in the proposal. So with respect to voter identification, Proposal 2 seeks to codify the current election law provisions regarding voter ID and placing those directly in the state constitution. Under current state law, registered voters, that's those individuals who appear in the state's qualified voter file, seeking to vote in person on election day or applying in person at their clerk's office for an absentee ballot must show their photo identification to receive a ballot. Under the law, if they are unable to present an acceptable identification to an election official, then they can sign an affidavit verifying their ID and receive a ballot and vote that ballot. The proposed constitutional language also stipulates that a registered voter who executes an affidavit would be allowed to vote on a regular ballot. The language further provides that a registered voter who signs an affidavit would not be required to vote a provisional ballot. So the language is very clear that says in the Constitution saying that the affidavit process will not put you in the queue for voting a provisional ballot. As a result, the voter would not have to subsequently verify their ID, proof of residence, as is required with a provisional ballot. The voter ID requirements here stand in contrast to the provisions that are contained in the Secure MI Vote petition. Under that proposed law, voters signing an affidavit would not receive a regular ballot, but instead a provisional ballot. And then after voting that provisional ballot, they'd have 6 days after the election to visit their clerk's office and present acceptable ID. As many of you know, Michigan has experienced an explosion in no-reason absentee voting since voters gained this right in 2018. Some 3.3 million, about 60% of ballots that were voted absentee in the 2020 presidential election. More recently, about 50% of the total votes cast at the August 2022 primary election, about 2.1 million, used the absentee voting option. This compares to less than 25% of ballots cast via absentee at the November 2018 general election, when voters had to select one of 6 reasons for voting that way. With expanded access to this method and more voters using it, some observers have challenged the security surrounding the absentee voting process and have recommended changes to it. For example, the Secure My Vote petition would require citizens to provide, in addition to their signature, their driver's license number, state-issued personal ID number, or last 4 digits of their social security number when they apply for an absentee ballot. Proposal 2 can clearly be seen as an attempt to head off such future legislative changes by codifying these existing provisions, voter ID provisions, in the state constitution. Proposal 2 affirms the current law that provides eligible voters with the right to be able to prove their identity by supplying a signature to the local election official when requesting an absentee ballot or when voting by absentee through the mail. Further, the proposal details the procedures that local officials must follow to verify signature supplied on an absentee ballot application or a returned completed ballot. In both cases, the constitutional language directs the election official to compare the signature provided by the voter to the voter's signature contained in the state's qualified voter file. The language further states that if an official is unable to match the signature provided, or the voter fails to sign either the application or absentee ballot, so in other words, they completed the ballot, sent it in, but forgot to sign it, the voter then has the right to be notified and afforded due process, including an equitable opportunity to correct the signature issue. So basically, local clerks would be responsible for contacting voters who submitted unsigned ballot applications or the ballots, and folks would have to go down to their local clerk's office to provide that signature. Also related to the absentee voting, Proposal 2 requires the state of Michigan to cover postage costs associated with returning absentee ballot applications and ballots. Requires the state to operate a system to track absentee ballot applications and ballots. The system must provide citizens with the ability to obtain their status of the submitted absentee application or ballot, and it must provide voters with notification and instructions about deficiencies in their application. So here we would have the signature, a missing signature on a ballot, returned ballot. The system would allow a voter to go in and see that their ballot is lacking that, and they would have to get into the clerk's office to take care of that. Further, the proposal would supply every municipality with a secure drop box to accept absentee applications and ballots. Local jurisdictions with 15,000 or more registered voters would be provided multiple drop boxes at state expense, with the requirements that the boxes are distributed equitably throughout the municipality. All drop boxes would have to be accessible 24 hours a day for 40 days prior to election day and up until 8 p.m. on election day. So this 40-day period matches the 40-day window that we have for voting absentee approved in 2018. Finally, Proposal 2 provides voters with the right to request an absentee ballot for all future elections by making a single signed application. The right to receive future absentee ballots could only be rescinded under 4 conditions, and those being if the voter requests to do so, if the voter is no longer qualified to vote, if the voter has moved, or if the voter fails to vote for 6 consecutive years. This provision, the kind of future ballot provision, is really intended to require local clerks to maintain a permanent absentee voter list for their jurisdiction and require them to send absentee ballots for each election. The postage costs for required mailings would be covered by the state of Michigan under this proposal. So early voting is brand new, at least in the form that's being proposed in Proposal 2. We do have early voting in the form of the no reason absentee voting, but what we're talking about here is a new in-person early voting option that would be available for all statewide and federal elections. Voters would not need an excuse or a reason to show up at a polling site to do early voting, just as they're no longer required to provide a reason excuse to vote absentee. But unlike absentee voting that largely occurs through mail-in ballots, some people do absentee ballot voting at their clerk's office when they get the ballot, but most send it in through the mail. In-person early voting would take place at designated voting sites. These sites would be required to operate the same way and be subject to the same requirements as polling places open on election day. Similarly, voters at these sites would have the same rights and be subject to the same requirements, photo ID, for example, for obtaining a ballot, that govern in-person voting on election day. Under the proposal, all citizens would have access to early voting for at least 9 consecutive days before election day. At a minimum, early voting sites would have to be open beginning on the second Saturday before election day and remain open through the Sunday before election day for at least 8 hours each of these days. Local clerks could allow early voting sites in their jurisdictions to be open for additional days or hours. That's at their discretion. Importantly, the proposal prohibits state and local election officials from reporting any results from early voting until 8 p.m. on election day. This is the same time that in-person voting sites close. It should be noted that the state and local election officials currently are prohibited from reporting any preliminary results before 8 p.m. on election day. So there's no change here with reporting results. The type of in-person voting here that would be required under Proposal 2 is available in 34 states. A handful of states allow both in-person voting and no reason absentee voting. For example, Michigan's neighboring states are mixed on this in terms of the voting options. Ohio allows both forms of early voting, absentee and in-person. Indiana law only authorizes in-person absentee voting, and Illinois provides only in-person early voting, like what is being proposed for Michigan here. The details of how early voting works in each state vary considerably. For example, states set different lengths for their early voting periods, with an average of about 23 days among the states that allow this. Similarly, there's variation across the states in terms of start end dates for the early voting periods, as well as making in-person polling sites open during the weekend. Proposal 2, as I note, sets a minimum of 9 days for a minimum of 8 hours of early voting, but it does provide local clerks the discretion to extend this voting period or expand the hours that are available. And also, clerks would be able to use early voting for other elections other than the ones that are required under the proposal. So in terms of impacts here, clearly the early voting provisions will change how voting works in Michigan. It's going to give voters another way to vote. That is going to be a change. Some are concerned about expanding absentee voting and in 2018 and with the provisions here in 22 that it will result in more fraud, voter fraud. But looking at the research evidence, there's really no evidence to suggest that absentee voting is any more prone to fraud than in-person voting. And it's important to note that Michigan has a number of safeguards already built into election law as far as administration to protect the integrity and security of absentee voting. So mail-in voting is changing how voting occurs, but it does not materially impact voter fraud. And there's really no evidence in the research literature that absentee voting expansion of it will provide any partisan advantage. For those who are concerned about making identification requirements more strict, and it's clearly it's going to be more of an inconvenience when you make identification requirements more difficult. It has the potential to suppress the vote in minority districts or minority communities where people might not have government issued ID for various reasons. So what we see is, in the literature at least, is when identification requirements become more strict, there's kind of a push-pull here, and when the pull is to really increase efforts to facilitate the voter turnout among those communities where the stricter voter ID requirements are most impactful. So really on net, there's not much change. In terms of fiscal impacts, there are some involved with this proposal. The new voting rights are going to result in higher election administration costs. These costs, while indeterminate, are likely to fall primarily on cities and townships, as they're responsible for conducting all elections. For example, there'll be additional local costs associated with implementing the early voting provisions. This is primarily entailing staff for in-person sites operated by clerks. The proposal allows jurisdictions to operate these sites either separately or in conjunction with neighboring municipalities or with their counties. So it's opportunities for some economies of scale here. If approved, Proposal 2 would require state government to pick up the prepaid postage costs associated with returned absentee voter applications and ballots for every jurisdiction in the state. These costs will vary from election to election based on the number of ballot applications returned for processing and the number of ballots returned for tabulation. Postage costs will also vary by district, by jurisdiction based on the length of the ballot. Longer, heavier ballots are going to require more postage. We just did a quick calculation for the August 22 primary. About 1.3 million voters requested an absentee ballot, and roughly 85% of those voted absentee. Based on these figures, statewide absentee voting prepaid postage costs would total about 1.7 million. So the key takeaways with Proposal 2, very important issues raised by Proposal 2 and the specific policy positions contained may very well be good, sound positions. Many Michiganders exercising their right to vote in the future might benefit from their adoption and inclusion in the state constitution. Several of the provisions will make voting more accessible, convenient, while also protecting the integrity and security of the franchise. And clearly, many of the topics addressed via the proposal have been subject to public debate within the Michigan legislature. The key issue raised by the proposal deals less with these specific policies themselves than whether these policies should be enshrined within the state's constitution. Nothing would prevent the legislature, under its current constitutional authority in Section 4 of the Elections article, from adopting any of the policies contained within Proposal 2. They don't need a constitutional amendment mandating them to do that. However, advocates for the amendment seek to bypass the legislative process to safeguard some new and many current voting and election processes from future legislative discussion and modification. But in doing so, these provisions can only be changed in the future through another statewide vote. One final note before I sign off and kick things back to our friends at Mears for some questions. As I've noted throughout my presentation, Proposal 2 contains language that conflicts with the language contained in the Secure Michigan Vote petition. For example, the voter ID requirements. If both Proposal 2 is adopted and is adopted by voters and the Secure Michigan Vote petition becomes law, a relevant question is, well, what language takes precedence? The answer, as it relates to specific provisions where there is a potential conflict, the language of the Michigan Constitution will always take precedent over statutory law, even initiated laws like Secure My Vote. It must be noted, however, that the Secure My Vote petition includes a severability clause to clarify that if any provision is found to conflict with the Michigan Constitution, that it can be severed from the petition and all other provisions implemented. So only the conflicting provisions can be stripped from the Secure My Vote petition if voters adopt Proposal 2. And with that, I'll kick it over to Mears for some questions. Oh, I'm sorry. Proposal 3. My bad.
Okay, so I'll be discussing Proposal 3, Reproductive Freedom for All. So what is Prop 3? This is the language that has been approved by the State Board of Canvassers for the ballot. It's a proposal to amend the state constitution to establish new individual right to reproductive freedom, including the right to make all decisions about pregnancy and abortion, to allow the state to regulate abortion in some cases and forbid prosecution of individuals exercising that established right. So I will go through more of these in detail a little bit further on, but I wanted to put the language up for you to see. So a quick overview of what I will be talking about today. I'm going to go through a brief timeline and history of the laws governing abortion, particularly in Michigan, as important background. I'll provide more detailed summary of Proposal 3 and its key provisions. And then I'm going to discuss 3 potential pathways forward based on the potential outcome of the ballot proposal and the impacts that could follow. So quick timeline. Most states, including Michigan, had laws that prohibited abortion to some degree. Michigan first passed their laws on abortion in 1846. These were later recodified in 1931. This might be why you've heard people refer to the 1931 statute. The language was actually first passed in 1846. Michigan had a law that penalized individuals that take certain actions to procure a miscarriage, with an exception for when it is necessary to preserve the life of the woman. And this applied to pregnancies before the state of quickening, which is generally referred to as the first fetal movement. There was a separate law that prohibited the willful killing of an unborn quick child. So even back in 1846, they were differentiating between different stages of pregnancy. Since then, at that point, there in the 20th century, a growing public health movement to legalize abortions, which culminated in the 1972 U.S. Supreme Court decision, Roe v. Wade, which established a constitutional right to abortion. It ruled that the right to privacy encompassed the right to abortion in the first trimester, making state bans on abortion procedures in the first trimester unconstitutional. In 1973, the Michigan Supreme Court case People v. Bricker specifically invalidated the 1931 statute that had criminalized abortion and basically said this was unenforceable for abortions in the first trimester of a pregnancy. So after Roe v. Wade was passed, pretty much since the time it passed, several groups wanted to overturn it. And as that kind of movement gained steam, there were just more laws and regulations that started to regulate abortion in Michigan. There were several laws enacted relating to funding, licensing, informed consent, all sorts of things to try to regulate abortion even more. This happened in other states as well, culminating in 2022 with the recent decision, Dobbs v. International Women's Health Organization, which overturned Roe, said that the fundamental right to privacy does not include abortion. And so this kind of upended the legal framework that we had been accustomed to. In Michigan, as other states were kind of prepared for this to happen, there were some lawsuits filed in Michigan to invalidate the 1931 law, to basically argue that under the Michigan Constitution, this law would violate the fundamental right to bodily integrity. So before moving forward, I just want to do a quick recap of what fundamental rights are, just for background. So the due process clauses of the 5th and 14th Amendments guarantee that no individual shall be deprived of life, liberty, or property without due process of the law. This has been interpreted to include both procedural rights and these substantive or fundamental rights. And essentially what this means, these are rights that are significant enough to individuals that they can only be infringed upon by the government for very limited reasons. In order to restrict any sort of right, the government must show a compelling state interest, and that law must be narrowly tailored and the least restrictive means for accomplishing that interest. This is also known as the strict scrutiny standard. Examples of fundamental rights include the right to privacy, which have been interpreted to include the right to marry and contraception, other fundamental rights, for example, are freedom of speech and freedom of religion. So where does Proposal 3 come in? So this is another response to the Dobbs ruling, and it's an effort to protect the right to abortion. Basically, the goal is to get abortion established as a fundamental right in some way. One option is to have the Michigan Supreme Court establish it through a lawsuit. They would already find that the right exists in the Michigan Constitution. The other way is to get the right and the language explicitly established in the Michigan Constitution. That's where Proposal 3 comes in. It would add Section 28 to Article 1 of the Michigan Constitution. It's referred to reproductive freedom for all, and it establishes reproductive procedures and treatments related to pregnancy as fundamental rights. So I'll go through some of the key provisions and try to pick out things that I think are important to know. First, the language defines reproductive freedom as the right to make and effectuate decisions about all matters related to pregnancy. So this language is pretty broad and inclusive. It doesn't limit matters related to pregnancy. It doesn't limit it to certain procedures or certain treatments. It highlights some examples. It's also not limited to women. It refers to individuals as well. And basically the limits are that strict scrutiny standard for anything pre-viability, so needing a compelling state interest in order to regulate abortion, pre-viability. After that, the legislature is allowed to restrict as long as it does not threaten the life or health of the mother post-viability. There's also a non-discrimination clause, basically just says that this law cannot be discriminatory in how it is enforced, or this right cannot be protected in a discriminatory way. And there's also a clause about protection against prosecution, which essentially means that Proposal 3 would explicitly prohibit the state from criminally prosecuting individuals who are exercising this right, either for themselves or in assistance of someone else. The language also goes into a little bit more detail about what a compelling state interest is in this case. So under this amendment, the compelling state interest must protect the health of the person seeking care. This is a little bit different than what compelling state interests have been in the past, in which the life of the unborn could potentially be a compelling state interest, but that wouldn't apply in this case. It must protect the health of the person seeking care. Must also be consistent with accepted clinical standards of practice and evidence-based medicine, and it cannot infringe on the individual's autonomous decision-making. Fetal viability is also defined as the point in pregnancy in which there is a significant likelihood of the fetus's sustained survival outside of the uterus without the application of extraordinary medical measures. This language is not defined further, so it's a little bit unclear what exactly this means. And this point in pregnancy, when this point is, will depend on the particular facts of the case and the professional judgment of a healthcare professional. So it's not like fetal viability would be at a set number of weeks, and it could be different depending on each pregnancy. Lastly, there's a clause on the execution of the amendment that basically means that it's self-executing, and the entirety of the amendment can go into effect without any additional legislative action. And any subsection that is found to be invalid could be severed from the rest without it invalidating the entire amendment. So as I mentioned before, there's 3 potential outcomes or pathways that could happen as a result of the ballot proposal. I'm going to go through each of these different scenarios. So the first is, in this scenario, there would be no constitutional right to abortion. In this case, Proposal 3 is rejected and no right was established by the Michigan Supreme Court. The second scenario is that there is an explicit right, constitutional right to abortion. This would happen if Proposal 3 is adopted, and that would create that right pre-viability. The third outcome is that there's still a constitutional right to abortion that is established implicitly by the Michigan Supreme Court. So even if Proposal 3 is rejected, this right could still be found by the Michigan Supreme Court. And I'll go through each of these pathways. So pathway 1, in which there's no constitutional protections for abortion. So there's no, in this case, no explicit right to abortion, and no implicit right to abortion is established by the fundamental right to bodily integrity by the Michigan Constitution. In this case, regulations on abortion and other reproductive care would be left entirely to the legislative process. And so that means that whatever current Michigan law could become active. And the current Michigan statute prohibits abortions in all cases except when necessary to preserve the life of the mother. It is among the strictest in the country. It does not have an exception for rape or incest. The legislature in this case could pass different laws on abortion that could be more or less restrictive than the current statute, but it would be in the hands of the legislature to either repeal the law, to amend it, to make it more or less restricted. That would be in their control to do. So there's some potential impacts. I'm going to discuss a little bit of legal impact and just broader societal impacts. The legal impact, basically, providers would become vulnerable to prosecution and imprisonment for continuing their services. Other state laws that restrict abortion allow exceptions for protecting the physical or general health of the woman, but Michigan's law requires that it has to protect the life, and so only laws that, only abortions that would be necessary to protect the life of the woman would be allowed, and so that might lead providers to be unsure about how severe of a health condition does an individual need to be experiencing to justify providing that service. So they may be hesitant to provide those kinds of services. Some of the language of the 1931 law may also be challenged in court. The Supreme Court has, Michigan Supreme Court has spoken to a few things about the 1931 law, but since it has been mostly inactive for decades, it is possible that there's maybe some confusion about how it might be interpreted. And providers generally only change their behavior if the law is adequately enforced, and this could really vary depending on the preferences of local county prosecutors. It could depend on who the state AG is at the time. So this could lead to some variation in which you can still obtain access to abortion in some counties and not in others. The general societal impact, this would lead to a reduction in the number of abortions performed, which inevitably would increase the birth rate. And this could have both positive and negative impacts on society. There's arguments for both. The increase in birth rate, one of the potential arguments is that this could lead to a larger burden on state services, on the healthcare system as more individuals are experiencing pregnancy, on the education system, on the foster care system. But there are also arguments that an increase in birth rate could have some positive effects for increasing the state workforce, making more children available for adoption for those that want it, et cetera. There's also just a general impact on the physical and mental health of the individuals who have to experience pregnancy, and and their inability to function as individuals and how that could potentially impact society at large. And then there's the fact that the county by county variation could exacerbate existing health disparities among these counties, in which some individuals that already are more vulnerable to certain negative health outcomes might also have a more difficult time gaining access to any abortion or other reproductive services that they might need. The second pathway, which Proposal 3 creates an explicit constitutional right to abortion. In this case, individuals will retain the access to abortion they had prior to the Dobbs decision with fewer legal hurdles, and may have increased access to abortion at later stages of pregnancy. So if this right is established this way, it would apply to a wider range of healthcare services beyond abortion. So this may apply to significantly more people. This would also protect the right to abortion from legislative override, because it would be explicitly established in the Constitution, and because the constitutional language would take precedence. Only another constitutional amendment could potentially eliminate or curtail this right, so it would make the right to abortion more secure. The potential impact of this scenario. So the language of the proposal is broad and undefined, so that could potentially invite some legal challenges. Just some examples that people have talked about. What does individual mean? Who does that include? What physical and mental health conditions are severe enough to be considered threatened by any given law? And are things like a ban on public funding, do those qualify as a discriminatory action? It's also unclear which laws could be impacted if the proposal passes. So there's, like I said, there's a lot of laws that currently regulate abortion, and so it's unclear which one of these would have to be changed or amended. For example, there's laws on informed consent, there is an insurance opt-out, and several others. The societal impact, basically abortion legalization in the literature has generally been shown to benefit women and society at large. It's found that abortion legalization generally in the past has increased women's educational attainment, labor force participation, and earnings. But there is limited data on expanding abortion access to this degree and just expanding reproductive health services so widely, because that is not something that has happened. There isn't much data about it. Some opponents of the proposal argue that expanding it to this degree could lead to more negative outcomes for women, potentially including riskier sexual activity. But like I said, there isn't data to really show this. So the third outcome that could happen, so the Michigan Supreme Court defined an implicit constitutional right to abortion. And this could happen, so if there's a lawsuit filed by Planned Parenthood of Michigan, and the Court of Claims has already found in favor of them, basically saying that the 1931 law is invalid and violates the Michigan constitutional right to bodily integrity. And that right has already been established in a previous Michigan Supreme Court case. However, the Michigan Supreme Court has yet to weigh in on this, and so it's unclear if they will agree with the Court of Claims or not. Any fundamental right that is established this way by the Michigan Supreme Court is likely to be narrower than the right that could be established by the language of Proposal 3. So with that, that means that the parameters of this right are more vulnerable to restriction by legislation if it is a more narrow right. In addition, just as Roe was overturned by later courts, if the right is established this way, that means that a future Supreme Court could also overturn this right. So overall, even if a right to abortion is established, it might be less secure than one that would be established by the proposal. So just some takeaways to leave you with. The reversal of Roe necessitates substantial legal and policy changes. Proposal 3 could potentially expand access to abortion to later stages of pregnancy. It could lift certain restrictions that have previously been in place and establish additional rights to a wider range of reproductive health services. Abortion legalization has generally been shown to have positive effects, but the impact of this expansive of a right is unknown. The proposal's language is broad and largely undefined, making it vulnerable to a host of legal challenges. If the proposal does fail, a right to abortion may still be found by the Michigan Supreme Court. And the current Michigan abortion law is among the strictest in the country, but how that is enforced is still up in the air, and it could vary widely by local county prosecutors and could vary widely across the state. So now I think we're going to pass it back to for questions.
Thank you, Craig, and thank you, Carly. John and Kyle, we turn it over to you for any questions you have brought or any you see from our audience.
I would like to start with one overall. It seems like these three proposals pack an enormous amount of public policy making into the Constitution. Is this occurring in other states? Is it just our state? Is this the trend, or what's your thoughts about that?
So it is happening in a few states that have fairly easy access to the initiative, and Michigan, of course, has that. We have the ability to initiate constitutional amendments, as we see here, also initiate statute. A few other states are dealing with the abortion issue as we are. And there's, initiatives on the ballot on a few other states on a number of issues. Really, the ability to go to the Constitution as commonly as we are in Michigan now, I would narrow down to California and Oregon, Louisiana, just a few states that have fairly easy access. And we really think, notwithstanding the merit or dismerit of any of these proposals, we've really settled into a bad practice of putting all this stuff into the Constitution. Maybe it's worthy of being in the Constitution saying we need voting rights, but it really is the job of the legislature to fine tune it and what it means to have early access and all this, and to put it in the Constitution in such detail, it just begs for future problems. And example one, I point out, we did voters, not politicians in 2018, this whole idea of a citizen redistricting commission, and they went through great detail on how everything should work. Lo and behold, we hit a pandemic, the census timing gets thrown off, the release of data to the states gets thrown off, and now that independent commission is in violation of the Constitution because they're not meeting the dates, where if it were a statutory implementation, it would be much easier to fix and to work with.
I got a question kind of follow up on that, Eric. So what matters do you think are appropriate for a constitutional amendment, and which ones should be left to more of a statutory fix, like a citizen's initiative?
Partly it's an eye of the beholder thing, right? There's no hard, fast rule of what it should be. I don't have the language in front of me. Generally, we want the language in the Constitution to be brief and general in nature and detailed enough to give the legislature direction for the implementation. So I don't know that there's anything really would be taboo for putting into the Constitution, but as a rule, we really don't need all of the detail on how every fine point should work, defining a postmark in the Constitution or the rules of procedure of that Citizens Redistricting Commission. It really, we've gone into such fine detail that we're going to be hurting ourselves in the long run.
I have a question specifically about Proposal 1. The financial disclosure provisions in that proposal, where would that put us vis-a-vis other states as far as reporting requirements? Would we be out on our own? Is there other things like it? How does that compare?
It is impossible to say, because all it tells us is that the legislature has to implement a law to deal with those things, but it doesn't say how strict the law has to be or any fine detail. And so I applaud them on that side, that it was general enough to leave the legislature latitude to do it. Some states their financial disclosure laws are so strict that they have to report receipt of a coffee mug or an umbrella or something like that. Even though the monetary value is so small, they are still receiving something because they are an elected official. Other states are more forgiving, a little laxer in what the threshold is. We won't know until the law is implemented how Michigan will compare to those things. And there's a lot of ethics out there, ethics issues out there generally This is just one element of it, and we would hope the legislature would tackle many other aspects of ethics that we have so far stood silent on.
I have a question for Carly on Proposal 3. Now, there's been a lot of talk about whether this proposal gets rid of parental consent. Can you just kind of walk through the situation in regards to that and the other laws? Because my understanding is you'd need a lawsuit in order for things like parental consent to go away. Is that an accurate description?
Yeah, so potential laws that could be invalidated, this is not something that would happen right away. For example, in terms of the parental consent law, so the fact that the proposal language refers to individuals and doesn't limit it to adults, potentially if this is in the Constitution, then there could be the argument, well, the Constitution gives minors this right as well. And so things like that could be, there would have to be in some case some lawsuit that brings up that wants this constitutional right applied, and so then the Supreme Court would have to speak on it. Other laws that could be impacted, it could also depend on some more executive branch or administrative enforcement of it. So some laws depend on certain executive officials from following through. So all of these laws basically, one, have to be enforced, and then two, have to be challenged. And if in that case, then the Michigan Supreme Court could then speak to it and make those decisions, but nothing would happen automatically.
I've got another one on Proposal 2, if I could, for Craig. And now I noted, I wrote down here that you said that the pre-postage requirement would cost, just if we used the August primary for an example, $1.7 million. But I mean, there's also cost to local governments for opening up for early voting. Some of these municipalities don't have bankers' hours. You get up north or you get in rural areas, and the clerk's office is literally somebody's living room. Who picks up the cost for these smaller local governments to have 9 days of early voting available? Is the local government stuck with this, or is the state reimbursing these communities?
Yeah, so on the early voting provisions, there is no cost reimbursement from the state to local governments for hosting 9 days, 8 hours a day of early voting. And as you know, and you pointed out here, a lot of these are clerks, are part-time positions. The staff that they rely on are largely volunteers from their community that they volunteer, they get paid to work those elections. They will also those individuals will get paid to work the early voting sites. And that's all of those costs, staff costs primarily, are going to come from existing budgets. There's no provision, taxing authority, no new taxing authority for local governments to tap into, and there's no provision for state reimbursement for the early voting. On the absentee ballot voting side of things, the proposal does put the onus on the state to reimburse locals for the postage associated with sending out applications, returning applications, and the ballots. I'd note that the state had access to about a $2 million fund to help cover the costs of absentee ballot application ballot returns during the 2020 presidential election, where we saw that huge spike in the use of this. But you've hit on a key point that I have heard from local communities, that there are costs involved, and the proposal's silent on those costs for local budgets.
And if I could just follow up real quickly, Craig. So we mentioned absentee, the early voting, and then the postage. Are there other costs that Proposal 2 would have on local communities that they'd have to swallow?
Well, those are the two largest ones that I'm aware of here. You know, the state already offers a system for tracking absentee ballots that is called for in this proposal. So largely it's just kind of, and the state picks up that cost, so that's not on the locals to do it. Those are the key costs that we've identified here in the proposal, Kyle.
I was thinking about the drop boxes. A lot of I guess the drop
Well,
boxes.
the drop boxes are being picked up by the state of Michigan, and that's you know, one per community. If you've got more than 15,000, you get multiple drop boxes. But most jurisdictions already have those drop boxes, but to the extent that they don't, they'd be entitled to one state-paid one. I don't know that there's a tremendous amount of maintenance costs with those that would fall on the locals, you know, whether it's painting them or shoveling the snow around them. But, you know, that cost is covered by the state of Michigan in this proposal.
Hey, Craig, one of the things the legislature did last week was expand by 2 days the pre-processing of absentee ballots. Does this proposal specifically address that as far as a time frame? I know it was an issue in 2020.
No, I mean, the way I'm viewing the absentee voting provisions in this proposal are, you know, identifying some of the costs with expanded absentee voting in the state of Michigan through the state now being required to cover the postage with that. The ID requirements obviously are being locked in. The current voter identification requirements that are in the election law are being locked into the Constitution here. That 2 days of pre-processing, you know, I think is going to make, you know, it easier on clerks to do the work that they're required to do, and obviously facilitate reporting results sooner rather than later. Again, results can't be reported to after 8 p.m. on election day, and that includes results from in-person voting at sites, early in-person voting at sites, and absentee ballots that have arrived up to you know, 8 p.m. on election day and processing those ballots.
I got one more question for Carly. If Proposal 3 were to pass, what kind of parameters could the legislature or the state have on abortion outside of some type of regulation at the time of viability for the fetus?
So the regulations pre-viability, it would be very strict. There'd be very little that the legislature could regulate. And, you know, the compelling interest, it would have to be to protect the individual seeking care. So various health and safety should still be able to be enacted by the legislature, anything that's going to protect the health of the woman seeking care. Post-viability basically gives them more leeway as long as whatever that regulation doesn't affect the life, physical, or mental health of the mother. And the trick is that's undefined. So what physical health conditions, what mental health conditions are something that is too severe for the legislature to regulate is still a little bit unknown.
But if I could, the legislature could define what mental health is after, presumably this gets adopted. Sure.
It's just not, it's how those mental health conditions manifest as well in terms of what impacts, you know, a mental health condition. It's a little bit trickier of a thing to define by the legislature. So it's possible that it could be stricter or broader. It's just hard to know how that would work out.
Carly, is it fair to say a lot of these questions are going to be resolved by court decisions post-adoption if it's adopted?
The biggest takeaway is that there's a lot still up in the air, no matter which direction, whether it's the proposal language or the 1931 law. Both of them will lead to a lot of questions, a lot of things that will then have to be later fleshed out by the courts.
Or also if the question is punted to the Supreme Court and and they decide. If suppose they say there's an implicit right in the Constitution, now we have to decide what that means.
Very good. I have no further questions unless you do, Kyle.
No, I do not. That
Great
was
show,
very
guys.
thorough, very thorough job, though.
So one of the questions that came in from the audience, we have just a few minutes left. Does this use of constitutional amendment for public policy substitute unlimited government by plebiscite instead of a legislature? And I think, as Craig pointed out in his analysis of Proposal 2, it's really what we're doing, that the Constitution currently grants the legislature the authority to create laws around the voting in elections, and we're usurping plebiscite instead of granting that legislature the authority to act. Craig, is there anything you would add to that?
Well, I wasn't going to offer this unless the topic came up again, but as it relates to Proposal 2, the early voting provisions specifically, this is where society is going, making voting easier. And as I scan what other states have done to implement those preferences, Michigan stands out as the only state that has, from my review here, that's locked this type of public policy into their state constitution by doing so in 2018 with the first Promote the Vote, the first version of early voting. Other states who've adopted this policy have done this through their statutory law, their code, their compiled laws. So Michigan does stand out, and I think it is an indicator of kind of public policy making in Michigan, going down this road of locking things in, preferences into the Constitution to shield them from either contemporaneous legislative deliberations or future legislation deliberations. It puts in the hands, of the voters some very weighty, important topics, but topics that in other states would be reserved to their elected officials to deal with.
And one final comment, we had a question from a community-based public policy advocate. Want to hear our thoughts on how existing term limits in Proposal 1 have affected or may affect the effectiveness on nonprofit advocates on public policy making. And to that, I would refer back to my comments on lobbying. What you're trying to do is influence public policy by interacting with the legislature and or the executive branch. And it just makes your job harder with term limits, because once you get somebody fully educated and understanding the issue and why it's good to vote one way or another to benefit that, they get term limited out, and you have to start all over with the next class of legislators coming in, or the next executive branch governor and his or her staff. I think the issues are really the same. So that handles all of your questions. Carl and John, thank you very much for joining us and helping us with this. Craig and Carly,
You're welcome.
thank you for your work on these. As I mentioned at the beginning, this has been recorded, and it'll probably take half an hour or so for it to process and us get it on the YouTube and then linked to on our website. And we're going to try at the same time to use the audio to put on our podcast and make that available for people who tune into the podcast. Thank you all, and remember, go out and vote and make your voice heard. Thank you.